Hello to everyone. I'm Brenda Salter. I'm one of your hosts, and thank you for joining us. Hopefully, you can hear me well. Um, and I would just remind you to communicate with us through the chat at the bottom of your screen. Your lines are muted, and also you can put questions into the Q&A box. As our presentation start, you will be able to type in your questions in the Q&A box at the bottom of your screen. See in the Q&A box, some of you are letting me know that you can't hear me. So I thank you for that you can't hear me. Hopefully, some say you can hear and you can hear the music. You also can hear the music in the background. So thank you. Welcome everybody. You have joined us for Georgia Fit's first program. And Georgia Fit stands for Georgia's Farmers Initiative for Training and Sustainability. This program is a joint program between the University of Georgia and Fort Valley State University Cooperative Extension Programs. We are excited to bring this program to you today, and we're right at 12 o'clock, so we're getting ready to get started now. We will start our webinar at this time. And one of our first tasks, let me just say before I start the introduction of our speaker, at this time, we will end the slideshow and we will also end our music. And again, I say welcome to all of you. We know that several more people may be coming in, and as they come in, those lines are muted so that we can make sure we hear the speaker. We ask you to sit back, make sure you have something to write with, and let's get started to learning this important information that our presenter has bringing to us today. Again, you have joined us for Who Gets the Home House, a workshop on estate planning presented to you by Fort Valley State University and the University of Georgia Cooperative Extension Programs. At this time, as I've said to many of you, but let me just repeat, I'm Brenda Salter, and I'm one of your co-hosts for today. At this time, my task is to introduce our speaker for today. So let me pause to do just that for you. And got so many things going here. Let's see, okay.
While Brenda is doing that, I am Keyshawn Thomas. I'm the Family Consumer Sciences Agent in Bibb County for University of Georgia Cooperative Extension. We are so excited that you all are here with us today. This conversation about estate planning is very near and dear to all of our hearts, and we have been working tirelessly to make sure that we have a great program for you today. Some of you have indicated that your chat is disabled. If you are able to communicate with us through the question and answer, then that is okay. We do have a committee that is working with us behind the scenes to make sure that we get everything answered. We would like to do a disclaimer that this information is for educational purposes only. While we do have a board certified attorney that will be presenting today, legal issues and estate planning is similar to our health makeup. Everybody has a different health profile as they do a different situation with their estate planning. When the time comes, we would like for you to put questions in the chat for the attorney. However, if it is very super specific and very super detailed, we may not be able to get to it today. We do encourage you to take this information as educational information. This is not to replace any legal information that you need to seek out for estate planning. With that being said, Brenda, are you ready?
Not quite, Keyshawn. Give me just a second.
Okay. In the meantime, we are enjoying seeing your information in the Q&A. Some of you guys I've been able to communicate with saying I can hear you're here. So we do appreciate you being here. This committee has been working tirelessly to bring this information to you, and we are from all different parts of the state, 2 institutions, and also our board certified attorney, and he is a certified, as Brenda will tell you in a few minutes,
I'm
about
ready.
in 2 different states. Okay, I'm turning it back over to Brenda. Thank you.
Okay. Thank you, Keyshawn. And again, welcome everybody. Let me introduce our speaker for today so we can get into the information we have for you here. Our speaker today received his JD degree from the University of Alabama, and he also received a master's degree in taxation from Boston University. Our speaker for today is also received a degree major in economics at Vanderbilt University and received a BA degree and a minor in business administration. He was admitted to the State Bar of Alabama, Georgia, of course, and South Carolina in 2001. Had multiple awards and has participated in many community activities. He has more than 20 years of practice. He has an extensive estate planning experience, probate, and corporate practice experience. He has experience in the state as well as the federal courts of Georgia and South Carolina. As I said, he is currently a title agent with the Chicago Title Insurance Company in both Georgia and South Carolina. He is a member of many of the Augusta Estate Planning Council. He's also a member of other local agencies, and we are very proud to many of us on the committee to have worked with him before, and we're proud to have with us today our speaker, Mr. John A. Donsbach, and he is the founding member and managing partner of Donsbach's Law Group, LLC. And his practice, of course, focuses in the area of business planning and formation, as well as estate planning, probate, and estate administration, also individual tax planning and taxation, as well as real estate. As I said, we are excited to have him. We've had the opportunity, some of us on the committee, some have known him for years and worked with him. So we're very confident that Attorney John A. Donsbach has some awesome information for us today. So without further ado, I give to you John A. Donsbach.
Hi, Brenda. Thank you for that introduction, and it's a pleasure to be here to speak to everybody today. If you can't hear me, let me know. You can send it to the Q&A, and they'll figure that out, I'm sure, or technologically. That's not my area. That's somebody else's. But as you can see, shortly I'm going to switch over to my screen so you won't have to look at my face all day, which is probably a good thing, too. But we'll get this presentation up and going. Estate planning for most people is a very important aspect of their assets and what they want to do. And as you can see, one of the things that we like to do is protect assets for the next generation, which is what we all seek to do and want to do. And, you know, the question that we get asked a lot when we are doing planning is people come into our office and will say things like, hey, I don't really need a will. I don't need an estate plan. I don't need all that complexity in my life. Well, that's just not true. And as we're going to get into detail here today, some of the documents that everybody needs are at least at minimum a will, a power of attorney, and a healthcare directive. And we're going to talk about those in more detail. But, you know, people will ask, why do I need a will? Well, as you can see, there are lots of reasons to need a will that aren't just, hey, it does something for my assets. For some people, if they have high tax values, which we're not going to get into a lot of detail on that today because the current exemptions under federal tax law are right at $13 million per person or $26 million. So for most people, you don't see a lot of estate tax issues anymore. The highest tax rate there is 40% and has been since 2020. But again, you don't see those problems for most people. Most people are really concerned about these other issues on this list, which are things like determining how to dispose of their assets, People are often surprised at what happens if they don't have a will, and we're going to talk about that in a minute. You have specific gifts that you may want to give to either charities or churches or specific members or other people. And that's one of the important things. Maybe your beneficiaries can't handle money very well, or they have issues with, drugs or creditor problems or asset management or any of those issues. Those are other reasons you need a will or trust or estate plans to be set up so that those things can be handled. Additionally, maybe you have people are going to fight over things. We had a situation where people fought over personal property in an estate, and it took 3 months, which is just ridiculous to do. But unfortunately, some people get in a fight over grandma's chest of cabinets and other things. And so wills will help avoid those type of disputes. If you have minor children, it's critically important to denominate or name guardians and conservators in your will to take care of those individuals. If you are a guardian for somebody already or overseeing, maybe you're a grandparent who is in charge of someone, those are all important reasons. And then finally, for a lot of people, it's just the peace of mind knowing that they have an estate plan and something is set up. And so those are the reasons that people should set up and should have a will that really have nothing to do with money or how many assets you have. And so everybody out there should have a will and go through the process. And, a staggering statistic out there is that they say approximately 2/3 of all adults do not have wills, which when you think about it is an unbelievable statistic, because that means under the state of Georgia and South Carolina or any other state that you live in, if you don't have a will, the state has determined that they've written your will for you. And in Georgia, this is what happens if you don't have a will. It's automatically determined by the state of Georgia that you do have a will and certain people will receive your property. This often shocks people when it comes to certain things like bank accounts or houses or other things like that suddenly people end up receiving. For instance, if you have just a spouse and the sole heir is your spouse, then it just goes to your spouse if there are no kids. But if you have children, this is where it gets really difficult if there's not a will. You could end up with a situation where your spouse and kids end up inheriting things together. Now, that may not sound bad until you realize that you're the mom inheriting a house with your minor children or with your adult children, and you need to go refinance the mortgage, and you can't without their permission. Or you need to take a loan or a line of credit on that house, and suddenly you have to get their permission to do that. And so if that happens, that can create all sorts of issues relative to disposition of assets and homes and things like that. Even worse is if you have a child who predeceases, then suddenly it brings their children into the picture. So you could have a spouse, a child, and grandchildren inherit a house or other items together. If you don't have any heirs, if you don't have any children or grandchildren or great-grandchildren, then it goes the other way, as we say, back up through your family tree. Suddenly your parents become potential heirs, siblings or nieces and nephews, possibly grandparents, aunts, uncles, you could even get down to first cousins. We have had estates where suddenly first cousins became a part of a home ownership that was involved. And, that can present real issues when you're trying to either transfer bank accounts, houses. The bigger issue we see is in larger tracts of land. When you get into farmland or other things, and people are suddenly inheriting acres together, and you have 10, 15, 20, 25 people who are inheriting the property together. And later today, we're going to talk about heirs property and some of those issues that come up. But these are all reasons as to why you need a will and why you want to sit down with a qualified planner and somebody who's done this before and knows what they're doing, and to work through these issues with you. And that's another point that I would make, is that when you are going to a planner, you need to make sure that somebody's asking you the right questions. And by that, I mean, and we'll talk about that in a minute after we get through these next few slides. But, most people wonder about kids. I've had people say, my kids, they're easy to determine. Well, sometimes they are, sometimes they aren't. We've had folks who have children out of wedlock, and they don't tell their spouse they have kids, who then show up at death. And nothing is more surprising to a husband or wife than a child they didn't know about showing up. Or we've had children that were born after the death of a parent because they were what we call in gestation during that time. And so when we have those situations, we have to worry and figure out who the kids are. And sometimes that's harder than you might think, because sometimes people aren't always honest with us because they don't want to tell us that they had another child, or they didn't want to tell their spouse they had another child. And we've had to do DNA testing and other things to prove whether somebody was or wasn't a child. So without a will, those type of complexities can be created. Now, if you do have those situations and you draft a will, those children can be included or excluded from the planning based on what you do. So it's important to make sure that you have a will, particularly too if you have adopted children. Those can create issues for parents, grandparents, and other people relative to those items. And so it's always important to do good planning with wills if you have a blended family, kids from different relationships or other things like that. And that's exactly this example that we talk about, where we have a blended family and what will happen with or without wills that can occur. And this often surprises people when they hear this. For instance, if you look at this example that we've put together, I've put together a hypothetical couple of Fred and Wilma. And they're married and they have a child together, and then they each have 2 children from prior relationships. This is not an unusual circumstance. Maybe the number of children is unusual, but we oftentimes will see people who have a child by a prior relationship, or their spouse has a child by a prior relationship. And this, without a will, can create real issues. As you can see in this example, if the husband or Fred were to die first with no will, his estate would be distributed 1/3 to his wife, and then 22% to their child, and then 22% to his other 2 children. Well, this may not be at all what they want to have happen. So in other words, his estate gets split between his 3 kids and his wife. And of course, Wilma's child or children are not part of his plan at all, which may or may not be important. And then, of course, if he dies with a will, as we see, leaves everything to his wife, well, that may be fine. But let's say Wilma doesn't have a will, which is what we've seen happen before. In that case, her 3 children split it, and Fred's 2 children would receive nothing. Now, the question is this really what Fred wanted? Is this what his idea was? Did he expect that at his wife's death, his kids would get nothing? Probably not. And there are ways to fix that with wills and trust planning and things along those lines. The worst example we've probably ever seen in our office was a couple who both had 2 children by prior relationships. They each drafted what we call the Honey, I Love You will. They actually went to a lawyer to draft this plan. The lawyer drafted the plan, and they each left their assets to each other because they were married and been married for several years. One of them died. I don't remember which one it was who died first. Their estate went entirely to their spouse. And then a couple years later, they met someone and got remarried. They went back to the same lawyer, drafted, again, what I call Honey, I Love You wills, which we leave everything to the surviving spouse. And then that spouse, who had been part of the prior relationship, died, and all of their assets went to the new third-party spouse in this situation. Well, the problem was all 4 children, both the husband's and wife's children, got disinherited in that estate and received nothing. And let this sink in a minute. They actually went to a lawyer to draft this. but the lawyer didn't ask the right questions and didn't ask about their assets and what they wanted to have happen to them. And so that is critically important when you are dealing with this type of planning, because if you don't do those things, those are the type of things that can happen. And, you know, as I said before, make sure that the person you're talking to has some experience and understands what they're doing in this area, because you can have really unintended consequences that can occur with your assets. And this is all of the list of assets that exist in somebody's typical estate that can be distributed in certain ways and with wills or not. Now, the first list of assets, insurance proceeds and the retirement assets, typically wills do not control those assets. And that's important to understand because the average person doesn't realize that. What does control those assets is their beneficiary forms. So it's very, very important that your planner is asking you these questions. What assets do you have? Because how in the world can I possibly do a will for you or do your estate work or plan if I don't know what you have? If I'm not asking you, do you have a house? Do you have land? Do you have insurance? Do you have retirement plans? I would seek another will planner because they aren't asking you the right questions to get it right and get your wishes put in action the way you want them. Because, as I said, on this list, the first few, the insurance proceeds, retirement planning assets, you need to make sure that your beneficiary forms are set correctly on those. We've had situations where people will walk into our office and attempt to have passed those in a will or other document and then realize that their beneficiary form with their employer controls those assets and it's still left named to their ex-wife. And they haven't changed that. And so it is important to make those changes. Stocks, bonds, mutual funds, cash, those type of assets can either be set in individual accounts or joint accounts. And in a minute, we're going to talk about some of the pitfalls of joint planning and issues that can occur because people oftentimes will put kids or spouses on joint accounts because they think it's a good idea. Or they go into the bank and the bank tells them, oh, just put their name on the account. It's no big deal. That way it'll pass to them or they have access to your account. That's not always the best way to do it and can create problems. And then, of course, real property in the form of deeds or trusts or LLCs, and we'll talk about that in a little bit, can be passed in other ways and in other processes. And then personal property. And honestly, this is where we see the most fights, is people are fighting over grandma's armoire or the china or the silver because it has emotional attachment. And they remember that grandma always used to serve the Thanksgiving turkey on this silver platter. And it's something they really, really want to have. And they tend to fight over. And so if you have people who really want certain items or you have a desire to leave certain items to certain people, make sure that your plan leaves those items to people in the way that you want and or sets out what we call a memorandum provision that lays those items out for people to be designated certain ways. And that can be done. Now, Georgia just changed their law about a year ago, and you can now do memorandums with wills and list long lists of personal property items to people, which is important because now you don't have to have me spend a bunch of time drafting it or charging you to do it. You can just attach a memorandum to the document that I do with proper execution and transfer those items the way you want to, which is a really good thing for most people under the law. Now, as I said, those are some of the reasons and ideas and why you need a will under Georgia law or any state. And it's a good idea to put those in place. And, these are some of the myths that we see a lot of times about estate planning. Oh my gosh, I can't go through probate. I don't want to do a will. Probate is a bad thing to do. Well, if you don't have a will, you're definitely going through probate. If you have a will, you're going through probate. And there are ways to avoid probate, which is what we call revocable trust or living trust planning. And that's not always well suited to all estates. I think there are a lot of firms or planners who push those or try to get people to get into revocable trusts, when in Georgia, it's not always the best planning technique because they're a little bit more expensive. They require more management. You have to transfer all of your assets into them. And so they aren't always the best and greatest vehicle for everybody. Now, they do make sense, and there are times to do them. But for most people, they aren't the end-all be-all, and they don't save estate taxes or taxes, and they don't avoid probate always, because a lot of people don't fund those trusts. And when they don't fund them, we end up having to go to probate anyway. So you pay the cost of the higher rev trust planning and still end up having to probate the estate, which for a lot of people doesn't make sense. And so again, I would tell you, go to a good planner, go to somebody who knows what they're doing, who asks the right questions, and walks through your planning and gets you in the right vehicles and right documents for what you need. And, related to that, a lot of the things that we hear are things like this. My estate plan is really simple. I don't need an estate plan. I don't need will. I've put everything in joint name. I put my wife as beneficiary on the policies, retirement accounts, kids are contingent. I'm not worried about it. I put my adult kids on all the accounts. I've got less than $1 million or $100,000 or whatever it is. I don't really need documents or estate planning. Well, all of those things could be true, but they might not be. And so the only way you're going to know that is to sit down with somebody and walk through your list of assets and what you have and what makes sense and what your goals are and who you want to leave it to avoid some of the pitfalls that can occur with designating these things. Because we've seen cases where people will name kids on the bank account. They have 6 children and they go, oh, I know little Timmy is going to share this account with his siblings. He'll take care of it. Well, guess what happens? When mom and dad die, little Timmy decides that they really did love him that much and he keeps the account. Well, guess what Georgia law says about that? Little Timmy gets to do that. It's his account and he doesn't have to share with his other 5 siblings. Well, how shocked do you think those 5 siblings are when they find out that little Timmy gets a $100,000 account and gets to go buy a car and a house and they get nothing? I can tell you they're awfully shocked and they're awfully mad too. And so when you want and have certain ways you want things to go, you certainly want to make sure that they're designated the right way. Now, I guess at this point, Keyshawn, I'm going to take a quick pause. And if there are any questions or anybody wants anything, we'll take a quick moment here to jump in on any of those, on any of these general first kind of points, if anybody has anything, and I'll let you kind of moderate that.
Yes, John, we do have a few questions. And one question is, in your example of Fred and Wilma, does it pertain to assets only in Fred's name? What if the assets were in both their names when Fred died?
Okay, that's a great question. And I've jumped back to Fred and Wilma. And what happens is any assets that are in Fred's name, and now I'm going to shoot back to that other screen that I had the asset listing on, because this is a very important point. If it is what we call a probate asset that's in Fred's name, it will go through probate in accordance with his will. So in other words, if it's a house and it was just in Fred's name, it's a bank account, it was just in Fred's name, it's cash, it's his car, it's a stock account, all of that that's just in Fred's name, his will control, or if he doesn't have a will, it will go through intestacy. Now, if it's insurance or a retirement account, the beneficiary designation on that account will control. So if Fred named his wife or he named his kids, that's what will control rather than a will or rather than the intestacy laws. Now, there are situations that we've run into where on the insurance proceeds or retirement planning that they don't have a beneficiary. And then you have to look to the contract to determine what it says. Sometimes it defaults to the spouse. Sometimes it defaults to the estate. Oftentimes, insurance contracts default to the estate, and then it runs through the estate for payment. So that's a great question. And now, jointly owned assets, let's say Fred and Wilma's name were on the house together or on real estate together. And this is kind of a trick question because it depends. It depends on how they've set up the deed. If Fred and Wilma's name are just on the deed together, i.e. they're both on it, then it's 50% in Wilma's estate and 50% in Fred's estate. So half of that real estate would still go through Fred's estate and could get really weird depending on whether he has a will, whether he doesn't. It could get really fractionalized. Now, and people go, well, isn't that a joint deed? Doesn't that mean it goes jointly? Well, that's the trick part of it. No. Under Georgia law, there are two types of deeds that people have with both names on them. There's what we call a tenant in common deed, which is what we just discussed, where just both names are on the deed and it's 50-50 owned. There's a secondary type of deed, which is called a joint with right of survivorship deed. And in that instance, both names are also on that deed. But following the two names, it has Fred and then Wilma's name. And then it has the little magic language right after their names that says, as joint tenants with right of survivorship, or language very similar to that follows their names. If that language follows on those deeds, then it is a joint deed, and at Fred's death, that deed would automatically transfer to Wilma outside of probate, and the will would not control. But again, you can see how important just sitting down with somebody who understands that and knows that and looks at your deeds and your real estate is, because oftentimes, and I'm a little bit different, Bert. I do a lot of real estate work as well, but oftentimes your closing attorney doesn't also do estate planning. And so the person who closed your house didn't necessarily set your deed up for estate planning. Whereas your estate planner is going to look at it and go, does this make sense? And so again, that's a great question because it's a very simple question, but it drives home the point of how complicated just the simple question of what if both names are on the deed can be, because it's not that simple always. And so, Keyshawn, did that answer their question?
Yes, I think it did. We have a few more.
Okay.
What if there is no spouse and there is a child but no will? Is the child the sole heir?
Yes, under Georgia law, if they are the biological child and there is no spouse, then the children are the next level to inherit. Yes. So the child would be a 100% beneficiary. Now, here's an interesting little wrinkle. If there was a spouse and only one child, the spouse and child would inherit 50-50 in that estate. Now, if there were a spouse and two children, the spouse would get a third and the other two children would split the other 2/3 of the estate. So if you have more than one child in Georgia and a spouse, it changes the percentage the spouse gets as far as intestacy goes. So you can run into some really weird results that way as well. But to answer that question directly, yes, if there's no spouse and only a child, the child is the sole heir.
Now we have another interesting question, which is a kind of, I think, a follow-up for this one. What happens when there is a will, but the child decides not to use it?
We have that happen sometimes as well, because they don't like what's in the will. And if you want to enforce a will, there are a couple ways, and we're going to talk about safekeeping later on in the presentation about where to put your will so that maybe the child doesn't throw it away or tear it up if they don't like what's in the will. But if the child doesn't use the will, there is a statute under Georgia law that says if you are in possession of an original will, you are supposed to turn that will over to the probate court in Georgia where the person lived, in the county they lived, within 30 days of their death. Otherwise, it's a misdemeanor not to do so. You could be held accountable for a misdemeanor. Now, I will admit, in my almost 25 years of practice, I have never seen anybody charged under that statute. Now, I will say I've used that statute as a threat to get a will filed in a probate court before, but I have never seen somebody actually get charged under it. And it depends, too, on why they're not doing the will, because if that child is the sole and only beneficiary, not using the will is going to be the same result as if they go through intestacy. But if they have other siblings that are to inherit in different ways under the will, then they could get, they could have a case filed against them for fraud or, all sorts of conversion of assets or other things if they were to hide the will when in fact it has other people who are beneficiaries in it. So the right answer is, if you have a will, turn it in to the probate court where the person lived and in the county they lived in. But if they don't use the will and they're the only child, there's really no harm or foul there. Nothing bad is going to happen. But if there are other heirs and people that are beneficiaries, they can get sued for, being nefarious with the document.
Okay, we have another question. Do I have to name an executor in my will?
Yes, you do, because if you don't, the probate court is going to name one for you. And the probate court could go so far as to even pick the county attorney, which is the locally appointed lawyer, to go charge your estate for money, which I don't think most people want to see happen. And so, and yes, there's a downside that some people see to executors in Georgia, which is they charge a fee. And the standard executor fee under Georgia law is 2.5% of the value of the assets coming in and 2.5% going out. Well, that's 5%. So on a $100,000 estate, that's a $5,000 fee. So, you can see it's a pretty expensive fee you get paid to be an executor. Now, if you draft a will, you can limit that fee. You can cut that fee down. You can say my executor won't get a fee if they choose to serve. You can say they get expense reimbursement. You can set their fee in the will if they serve. So if you think that the fee that they'll get under Georgia law is too much, you can set that fee. And so oftentimes, if we are going to name one child in a will to serve in an estate over the entire estate, we'll ask the parents, do you want them to receive a fee? And they'll say, no, probably not, because we don't want to disadvantage the other kids. We just want them to probate the will and get the estate done. And oftentimes that's a good plan too, because it takes away a lot of the conflict that can occur. Because, if brother Timmy is going to get paid to handle the will and you're not, why does he get paid and I don't, just because he got named executor? Whereas if he's not getting paid, Timmy has every reason in the world to get that that probate done quickly, so that it doesn't drag out, because he's not really getting paid and the assets are being distributed to he and his siblings. So there are all sorts of reasons to A, lay out your executors, and B, set fees and others in the will and address that situation.
Okay, there's another question. What if your sibling's name is on the warranty deed? This person is the 8th child of 8 and one of the siblings is deceased.
Well, if the parent put the child on the deed, depending on how the deed is structured, the entire property could end up going to the child. I would have to see, and all the other siblings might have gotten disinherited. I would have to see how the deed was structured. It really depends on how they set that. Again, this is why it's really important to set up estate plans with deeds and wills and have somebody examine all of those documents for you, because and set them up correctly. Because if the parent just goes and does that thinking, oh, they'll share the property with somebody else, that may not be the legal case that has to happen. And unfortunately, we see that happen more frequently than we should.
Okay. And what do you think of co-executors of an estate?
I think it depends. We've done them before. We've not done them. I have since, after 20, almost 5 years, I've quit trying to judge which estate it's going to work in and which one it's not, because I've had estates where I thought, oh yeah, these kids are going to get along great. We're not going to have a problem. And it was a nightmare. I've had estates where I thought this is the worst decision in the world to put these two kids as co-executors together, and it worked beautifully. And so I would tell you that I don't know your kids as well as you do. I don't know their interrelationship and their interpersonal play as well as you do. And it can create problems because both of them have to agree, if they're two, under Georgia law to do something, and you can run into a log jam in the estate getting things done if they get in crossways or get into a fight, and suddenly the estate just locks down.
We have one more question, and I want you, and then we're going to get back to your PowerPoint.
Okay.
But can you include wishes for future assets in a will that do not currently exist?
Wills do actually pick up after acquired assets. For instance, like a personal property clause, and that's the pretty standard one. You go buy a new car, right? The personal property clause in every will says, I give all my personal property at the time of my death to my kids or to this person, or the car I own at the time of my death is their car. Yes, if you have certain assets that you're going to acquire or that you do acquire, or you think you're going to inherit grandma's china, then you can put those things in a will. And to the extent they are there at your death, they will be transferred by the will. To the extent they are not, they will do what we call lapse, and the will not control. So for instance, if you leave a car to somebody, but you don't own a car at your death, then the car just doesn't go to that person because there isn't one in the estate. So yes, for after acquired assets, you can put those in a will, and you must own them at the time of your death for them to be transferred by your will. But if you do, then yes, that would work. Okay. Is that a good?
One last question. What credentials should someone be looking for? You mentioned to make sure that you have someone that has experience in this area with this type of planning. Are there specific credentials that a person should be looking for qualified individuals to help with this type of planning?
Yeah, I would say so. I would tell you that you want to look to somebody who holds themselves as an estate planner, but not just an estate planner. I would tell you, for instance, I have what we call an LLM in tax, or a master's in tax law, which means I went to an extra year of school to learn more estate planning, more tax law, and get really specialized in the areas of planning and dealing with assets and transfer. Folks who have LLMs in estate planning or have years of planning experience are the folks you want to talk to. You can tell immediately. I can tell you, you can almost tell immediately right off the bat if you've got a good planner, because the first thing they will do is send you a questionnaire, or in the first meeting, they will ask you all about your family. They will ask you all about your assets, and they will ask about everything that you own so that they can help plan your estate. If they aren't asking you those questions in either some form of questionnaire to you or some form of initial meeting, you got the wrong person, because they don't care about your estate. They don't understand what needs to be done or the questions to ask to do your planning. All they're going to do is print a will form off their computer and give it to you. And that can be a real risk, because there are a lot of lawyers, and I'll say this, there are a lot of lawyers who hold themselves out as estate planners who aren't estate planners. They say, I can do a will. I know how to do a will. I'm your real estate lawyer. I can draft a will. Well, that's not always true. And so you want to make sure that they're asking you the right questions so that you get the right treatment for your plan.
Okay, one last question. What's the statute of limitations for probating a will? I think someone had one and they never kind of went through the probate.
Interestingly enough, in Georgia, there isn't one. There's no set. You can probate a will just about at any. Down South Carolina, it's 10 years. But in Georgia, you can probate a will. As I've probated wills that were 30 and 40 years old. So, now doing that can create some problems if you've already had the estate transferred or real estate's been titled. It can create some real problems in the back chain of title on things, but it can be done. I would certainly tell you to go to a qualified probate lawyer before you do anything like that, to make sure what type of pitfalls or issues that could create. And so given that, I'm going to jump into the next phase of this, which is kind of the building blocks of an estate plan, which is some of the kind of the things that you need to go through. And so we've talked about revocable trust, and quickly, these are some of the times to use them. If you want to avoid probate and you need to avoid probate, maybe you've got, assets in other states, like you own property in South Carolina or Florida and Alabama, and you want to avoid probate in those jurisdictions, then maybe we need to consider setting up a revocable trust to get those assets titled into it. Maybe you live in a state like South Carolina, which has terrible probate laws and costs, and you want to avoid the probate process altogether. Then Rev Trust makes sense. Maybe you've been diagnosed with Alzheimer's or Parkinson's, and you have some health concerns, or you're single with those health concerns, or your spouse passed away several years ago. Okay, revocable trusts are starting to make a little more sense than wills to help you manage and handle your assets. Maybe you're concerned the kids are going to fight about it and you don't really want to open it up to a probate challenge or probate situation. Then maybe we do that. So, Rev trusts, as we talked about, which are an alternative to will planning, are sometimes a good vehicle. But again, I would tell you to talk to a qualified planner and do that. Now, here's the other thing with real estate, and this is often the question we get. Now, this doesn't always work real well with the house, the personal residence. But if you have farmland or timberland, or you have a rental house or other items that you want to do, and you don't want to do revocable trust planning, then LLCs are a great vehicle. We do a lot of LLCs for clients who have rental homes or have a rental house or farmland or timberland. And they're great too if you own property in other jurisdictions, because they help transfer the asset better, because now all I have to do is transfer membership certificates through the probate or through stock certificate transfers rather than deeds if I put property in it. I can avoid probate in other jurisdictions if I put land in Alabama, South Carolina, Florida, other jurisdictions in an LLC. It gives me a liability shield. If somebody falls and gets hurt on the property, I now have a protection that I can't get sued individually for my rental home or my farmland. Very important. It avoids the complexity of revocable trust planning during life or managing a rev trust during life, which is very important. And you can structure an LLC such that I don't even have to file a separate tax return. If I set it up right, I can do what we call a disregarded entity with it, and it be reported on your current tax return without having to do an entity tax return. All good reasons to have LLCs in real estate. So they are another estate planning tool or building block, as they say, for your planning if you need it. Now, this is just a quickie slide to get you a feel for how many people in this country really pay estate tax. So when the politicians start talking about estate tax, it's a joke, really, frankly. It only applies to the top 0.01% of taxpayers, or anybody who has more than $26 million under current law. And as of 2026, it'll be about 14 million. It's slated to fall back a little. So the estate tax discussion that you hear politicians talk about all the time doesn't apply to most people in this country. And it's kind of a misnomer when they start trying to convince people that they need to do certain things for estate tax. And so I want everybody to keep that in mind, that it's a very small percentage of the federal revenue that our country takes in this country. Now, we talked about the building blocks of estate planning and estate structures and plans. And this is kind of some of the old planning when we had, really low exemptions, and Fred would set up this complex planning under his will where he'd do a tax planning trust for his wife, and then anything above that amount would go outright to his spouse. Well, with these high exemptions, we don't need to do this type of planning anymore. So I'm not going to spend a lot of time on it. You don't see much of that anymore. What you see more of now is the type of planning that people will do. They may do trust planning within the will. In other words, they feel that they need to set up something to protect the kids. Maybe you've got minor children and you don't want them to inherit the property outright until they're maybe 25 or 30. Well, you need to see a planner to set up trust planning within the wills. Maybe you want the grandkids to have something, the generation skipping type planning. Then we need to talk about trust planning for them and how to set that up. There are reasons to not put things in trust as far as assets like real estate. It can have tax implications. You can step up in basis. And we're going to talk about that in a minute. If you just give the house away, what happens? That you can cause a tax problem that you didn't mean to. Maybe your kids need trust set up in their wills because they are spendthrifts. They spend too much money. You had a child with addiction problems, either alcohol or drugs, and they need protection. Maybe you have a handicap or special needs child that has some needs, and we need to do special needs planning or qualify them for, Medicaid and Medicare under the Georgia Peach Court and other things. All reasons to see a qualified planner to do trust planning and set that up. And those are all unique to everybody's situation. As Keyshawn mentioned in the beginning, that this is not a Band-Aid or silver bullet or one thing fits all. You need to see somebody who can work through those issues if you have them. But those are all parts or components of an estate plan that you need to consider when you're doing it. And maybe you have a spouse who can't handle assets. And that's when you may want to consider trust planning in your will for the spouse. Maybe the spouse doesn't handle money. Maybe they've never handled the finances in the estate very much, and they need somebody to help protect them. They need a trustee to oversee it. Maybe you're afraid the kids may come in and try to take advantage of the spouse, or the spouse is becoming, as we all get older, we get a little bit slower sometimes. We don't handle things as well. And we have seen situations where the kids come in and take advantage of mom and dad, or they take their assets. And that's not good, because mom and dad need those assets for their support and care. Maybe they need to be in a home or a nursing home. And so those are all reasons. And to that point, maybe mom or dad needs Medicaid, and they need to be in a nursing home. And that's a different style and level of planning as well that we need to talk about. And we need to qualify for Medicaid. And those are all very different rules than your normal planning rules. So if you need to do that, that certainly needs to be done by a planner or somebody who has experience in elder law or handling those things. Maybe you've got kids from a previous marriage that you're afraid are going to affect your spouse or wife, and you need to do trust planning there. Again, all good reasons to do trust planning in a will. And yes, it does create complexity when you do trust planning in a will, but it may be necessary complexity. Because as we talked about initially in the Fred and Wilma example, if you have a blended family or kids from different relationships, you can have really unintended consequences with the documents if the planning isn't done correctly or trust planning in the will isn't set up. And so those are all good things that you need to talk to somebody to set up a general plan. And so what that would look like maybe is it used to look like this, which was this credit trust or tax plan, and then a marital trust for the wife. But this is the old tax planning that we really don't do anymore. Maybe your will looks like this now, where you have all your estate assets, and then they just drop down in your will into a trust for your spouse. And maybe that trust says, after the death of my spouse, it goes to my kids, or it goes to our kids, or it goes to my grandkids, or it goes to my kids and some charities or the church, or it controls what happens to your assets. And all of this is done within the context of a will. You set the will up, and then the trust is designated and set up under a particular item in the will. And so think of it this way: this little green box of your estate assets at your death sit out there, and this box dumps over and funnels through your will. Your will is kind of like a little funnel that you set over this yellow circle or box, and all of the assets funnel through that funnel into that yellow circle. Maybe it's a trust. Maybe it's a will that says, give it to my kids. Maybe it's partly a trust for the wife, partly to the kids. But that's how the will functions in the probate process, is it takes everything you've got, runs it through that funnel, and disseminates it through that yellow circle the way you want it to go. That's what good will planning will do. And if you've done it right, it will avoid disputes. There won't be any challenges, because it'll be laid out very clearly in the will document how it's supposed to go, and everything will go exactly the way you want to see it go. Now, there are other things that we can do outside of wills that we talk about briefly here. You can do gifts. Now, I say gifts, we need to be careful in the gifting context, because a mistake that a lot of people make, they go, oh, I'm just going to give the house to my son or daughter. I'm going to give it to them right now because I don't want it to go through probate. I want them to have it. I want to make sure that happens. Well, the mistake that occurs there is what you are doing is locking in your basis in the house for tax purposes. So let's say, for instance, you bought your house for $10,000, but it's now worth $100,000. Well, if you sold your house because it's your primary residence, there's no capital gain. That $90,000 difference in what you bought it for and what you sell it for is not taxed to you, because it's your primary residence and you have a gain exclusion under the tax law. However, if your children tried to sell that house and you just gave it to them, they have a $90,000 taxable gain because it is not their principal residence. And suddenly they end up paying an $18,000 tax on that $100,000 sale. Whereas if you hold that house until your date of death in your estate, something called step up in basis occurs. And what happens is the value in the house in your estate, the basis jumps to $100,000, to where if your kids sold it, their cost basis in the house is $100,000. They're treated as if they bought the house for $100,000 because it was worth $100,000 at your date of death. And so that means that they could then turn around and sell it after your death for $100,000 for zero capital gain. So there was no tax. So the difference in giving the house away during lifetime or holding it through your estate was an $18,000 capital gain tax difference. That's a big deal on just a $100,000 house. And if the house is worth more, which most people's are, you're talking about significant tax differentials just because you chose to hold the house in your estate versus give it away. So again, before you make gifts or before you give assets away or do things, talk to a qualified planner who understands the tax implications and those type of things that they're doing so that you don't do those things. And then I mentioned these other things here, but most of these are done in higher net worth estates, you know, trust planning or family limited partnerships or charitable trusts and foundations and all those type of things that can be done are good things to do if you have more money. The other one I'd point out is the 529 plan for grandkids. A lot of people like to set up college education funds, and that's a good vehicle to do that. But now, we've talked about naming people in plans and assets and some of the problems and pitfalls with them. If you do joint planning, like we talked about before, hey, I'm going to name my kid on the account. I'm going to put little Timmy of the 5 siblings on the account. That, as we talked about, can disinherit other kids. It also could create a gift tax issue depending on the size of the account. Let's say I put little Timmy on a big stock account or my stock investment account. Well, that could be considered a gift. And we need to think about that and whether we wanted to do that because he also had access to it. And that's the bigger problem that occurs, is now the child has access to the account. And it might not be the child that's the problem, it's the child's creditors. We had a situation once where dad put his son on his bank account and the child had IRS problems that the dad didn't know about, and the IRS levied dad's bank account for $100,000. Oops, that's not a good result at all. And so if you are in that situation and you're naming your kids, keep in mind you are subjecting them, your accounts, to their creditors. And so that is a bad idea to put them on a joint account or jointly on property or other items. So people go, okay, well, what can we do if I need to have them have some access or control to this? The right way to do that is set them up as a power of attorney and give them fiduciary control as what we call a POA, or name them on the account as a power of attorney. Banks can do this. You can set up the account rather than a joint name as a power of attorney account. And that's very important because it avoids a lot of these problems. And so, and the problem is sometimes people walk into a bank too, and the bank will say, oh, just set it up as a joint account because the bankers don't know any better. And that's the scary part. You lean on these financial folks for a little bit of help, and they don't know the laws either. And they just say, oh, just put your kid on the account. And then suddenly you've opened it up to their creditors. You've created this estate problem with the account that you didn't even know existed. The right way to do it is to do it as a POA account or a power of attorney account. And so those are all of the right things to do there. And that's what we talk about here, is other documents that need to be done as part of this process, which is the financial power of attorney, durable healthcare power, and maybe investigate whether you need long-term care insurance. And, you know, with these documents, power of attorney, this is the document that gives people the right to handle your financial affairs or financial documents for you. And they can be general or limited. They can come into effect during life or after life. Georgia just created a new statute in 2018 that totally changed our power of attorney statute. So if you haven't done a power of attorney in a few years, you probably need to update yours. Your old ones are still good if done before that, but the new one is a totally different statute, and it's important to get it done. But this is the person who handles your financial things if you can't. And the people that should be your power of attorney are someone who's going to act in your best interest and handle your assets that you trust. Do they have good financial abilities? Do they have good business acumen? Are they trustworthy? Do I trust them to pay my cable bill and my mortgage if I have a car accident? That's the person that you want to name as your power of attorney. Don't name the child who has addiction problems. Don't name the child who has creditor problems. Don't name the child who could never balance their bank account. Believe it or not, we've had people try to do that over the years, and it is a recipe for disaster. And so I would tell you, make sure you work through and think through who those people should be. As I just mentioned, these are the people that shouldn't be your power of attorney. Your favorite caretaker, and believe me, this happens to grandma and people all the time, where the caretaker tries to get in good with the family member in an effort to get control of the finances. You know, as I said, irresponsible children or family members, third parties that befriend you who are trying to get control of the assets, or people with poor financial judgment should never be your power of attorney. So, and you're going to have to work with your advisor to tell them who those people are. I don't know your family members, nor does anybody who's working with you. So you're going to have to be honest and upfront with your advisors of whether or not people can handle this role, because it is an important role, because it's a role for you as the person who needs the power of attorney. And then the other document that you need in addition to the will is the healthcare directive. And this is the person that helps make decisions for you for healthcare and where you end up. Do you end up in a nursing home? Do you get care at home? Do you have caregivers at home? You know, those type of things. And then these are, again, are the considerations that you think about when naming a healthcare agent. Who is the agent? Will they carry out my wishes and desires? Do I trust them to do that? Will they have the emotional strength to pull the plug if I need them to do that? Will they be able to look at the doctor and look at my children and say, no, let them go. They are DNR. It is a hard decision sometimes, and it is a tough position sometimes. And it is something that you have to think about if that's the person you want and trust to do that. But it's important, because we all will likely end up in a situation where we need somebody to make healthcare decisions for us. And so you need to think about who those people should be and who you trust them to be. And these are the type of decisions that a healthcare agent makes. Some of these surprise people. Under our law, the healthcare agent can decide whether you get an autopsy. Does your body get donated? Are you an organ donor? Even though your little card says it on your driver's license, the healthcare agent has some control over that. Do you get buried or cremated? That's the healthcare agent. We have had a fight in a family before between a healthcare agent and what they thought mom wanted. And the healthcare agent won in court over the issue of cremation. So this is an important document for people in that. It helps decide what happens if you're in a terminal or vegetative state. Can determine if you're female, what happens if you're pregnant and have problems in health situations. And then finally, and most important, this document will help appoint a guardian for you in writing if you need one under Georgia law. So these documents, as I said, are critically important. Wills, powers of attorney, healthcare documents do all of these things. They help save cost in administering the estate, peace of mind that your estate will be carried out, the efficient administration and disposition of your assets, reduction of family friction, and just frankly, management of the assets in your estate, and then the rest to make sure it happens. And that's important. And it's hard to believe that these three little documents can do that. But these three little documents can save thousands, if not tens of thousands of dollars in cost. We as a firm make more money on estates that don't have wills than on the estates that we actually did will planning. And let that sink in. As a lawyer, I lose money if I do a will for you because I make less money because it's been done right. So that's important for you all too. It's worth the cost to have these documents done because they are hugely important in so many ways. Now, finally, where should we store these documents when we have them? Well, if you have a fireproof safe at home, let's put them there. If you have a safety deposit box at a bank, that's great. We have seen some problems with safety deposit boxes if a child or somebody else has access to the box because documents sometimes get removed. Now, if they're not on the box, don't worry about that. You don't have to put them on the box. Under Georgia law, I can petition a probate court to get access to a safety deposit box after death and inventory that box and get possession of any estate documents in it. So don't worry about putting kids or other people in a safety deposit box. Just let them know you have it so the lawyer can access it. Because that way, whatever you leave in that box doesn't disappear. I've had jewelry disappear. I've had cash disappear. I've had other things in safety deposit boxes that people wanted to go certain ways vanish because people put kids or cousins or other people on the box. Keep that in mind. If you want to protect your will and you don't want to store it in a fireproof safe or a safety deposit box, file it with your local probate court. Every probate court in this state can take your original will and hold it on file for you. Usually it's a $10 fee in most courts to file it, and then you don't have to keep it. Then at your death, the probate court will already have your will. Some people really like that, and that's a great way to have it protected if you're worried about it. The other thing that we've been starting to tell clients with regard to healthcare directives is everybody has a cell phone now. Save these documents on your cell phones in PDF format, not necessarily your will or power of attorney, but your healthcare forms. We used to tell people to save copies of them in their glove compartments in their cars, because when are you going to need the healthcare directive for mom, dad, or each other? When you're in an emergency situation. It's never going to be that planned surgery that you can bring it to the doc's office and everything's going on. It's going to be in the situation where an accident happened and you had to race to the hospital and you're going to get there and they're going to look at you and go, do you have a healthcare directive for this person? And you're going to go, oh my gosh, that's at home in the lockbox, or it's at the bank and it's after hours. So if that's the case, save a PDF copy of both of your healthcare directives for each other on your phones, because when you need it, you'll have it. And then guess what? You can then email it right there to the hospital provider or the nurse or whoever you need to get it to. So just as a practical FYI, that's a great thing to do. Now, Keyshawn, I'm gonna call on you at this point because I've rattled on a little bit longer here, and I'm gonna let any questions and jump in for a Q&A session before we jump into the probate process.
Okay, I am here and we have quite a few questions. One question is, what if you die and you have no heirs to your will? How do you portion your assets to multiple charitable organizations? So this person has no heirs and they want to leave things to charitable organizations.
Okay, well, that's very easy. You just name them in your will. We often tell people the best way to do it is by percentage. And you name an executor in the document who makes sure that that percentage of your estate is devised to those charities. Now, if you have certain assets like a house or certain things that are not liquid at the time of your death, the executor that you name will be in charge of selling those assets and liquidating them, maybe a personal property. They'll have an estate sale and liquidate those assets and turn them into cash or money. And then let's say once they do that, they end up with $200,000 in the estate. They sell your house, they sell all your personal property, and there's $200,000. And then your will says, I want to leave 10% of my estate to the church, 10% to my favorite child charity, 10% to the cure for Alzheimer's. That means that the executor would then take 10% times 200,000 and distribute 20,000 to one charity, 20 to another. We advise people to do it in percentages because nobody knows what their estate's going to be exactly worth at the time of their death. Now, some people want to leave a specific amount. They want to leave $5,000 to their church, and that's fine too. But if you want to leave your whole estate, then doing it in percentages like that is the best way to do it.
Okay. We have another one. Are you saying that LLCs are suggested for land and homes instead of deeds?
Yes, and not necessarily the home itself. As I said, LLCs aren't great vehicles for the personal residence. It's the one exception to the LLC rule. But for anything else, for rental homes, land, yes, because here's why. In order to transfer the LLC interest to a child or children, all I have to do is open up the stock book, issue new stock shares to them, sign it with the new owners of the LLC, close it, and I've done it. I don't have to draft a deed and file it with the county. I don't have to do any of that because on the county records, the LLC is listed as the owner of the property. The other advantage of it is nobody really knows who now owns the land. I can't start getting calls about sales on my land or the rest. They're going to call the LLC registered agent or whoever's listed with the Secretary of State. So they don't know who to call or who owns the land. So yes, I would tell you that LLCs are better vehicles than just a deed for transfer of those for varying reasons, and it creates liability protection. So yes, I would say that.
If heirs property goes into foreclosure and one heir pays to get it out of foreclosure, is that heir now the owner of the property? If not, is that heir legally owed the foreclosure monies from the other heirs who did not contribute to the foreclosure debt?
The heir is not the owner of the foreclosure property because it's still titled in the name of the other folks. And that's also true on tax sale deeds. You have to be really careful with those too. That's another form where the county comes in and it's like a foreclosure with a tax sale deed, and they create their own problems. Please see a qualified person on those as well. But no, if you pay the foreclosure amount, you've paid it off. Now, the real problem you've got is technically you don't have a lien or anything on the property by paying, because you're not the bank, you're not the security deed owner, you're nothing like that. So to get your money back, what you are going to have to do, one of two things. You're going to have to file an accounting action in the Superior Court against the other landowners to get your money paid back, saying, hey, you other landowners, I paid this, saved it from foreclosure. I paid the taxes, I paid the foreclosure money. You owe me this money back. Pay me. Or you can ask the court to partition it and sell it or get rid of it. Now, you have to be real careful, though. There is a little hiccup in the heirs property law statute. If you do that, and we just caught a guy recently with this, and he didn't know this was in the statute. If you file the petition seeking heirs property to be partitioned or sold, and you are the petitioner, i.e. the plaintiff, the person who files that petition, you have just made an offer to the other heirs to be bought out. The statute says the person who files the action puts their property interest at risk of being bought out under the heirs property statute after appraisal. A lot of lawyers don't realize that, and they advise people to file that without telling their client that. And I can tell you, there will never be a madder client in the world than the client who comes to you after you file that and says, you're telling me I'm losing grandma's farm because I filed this action that you told me I needed to file? Not a good place to be, particularly if you're the lawyer, an even more uncomfortable place to be. So do make sure that you've had the full conversation if you're going through and doing things like that. But no, you don't own it, but you do have recourse through the courts if you need to.
Okay. Now we have a viewer that has a 90-year-old mother who has a will and a advanced medical healthcare directive, but they want to make sure and put some provisions in place in case she needs long-term medical care that won't jeopardize her house.
Yeah, that's where we're getting into Medicaid planning. And if she needs to go to a nursing home, and that's a much longer discussion, because that's a discussion of possible trust planning for her, whether she needs Miller Trust for income issues. Does she need trust planning? You got to be really careful with gifting the house because it can disqualify. Do we want to set up certain loans or other ways to, that's a much longer conversation on how to do that. You need to see somebody who's qualified in either elder care or estate planning with those folks and do that, because that's a different animal than I have time to go through.
Okay. What if Fred created a deed with only listing one child without a spouse? Will the other children still be entitled to a certain extent?
If he gave 100% undivided interest in that deed to the child, no.
Okay.
If the deed purports to give all of his interest and not just a portion, no. The other kids are gone. They're out. If the deed transfers the property and the will doesn't, help you.
Okay. What is the best route for an unmarried, childless person who the parents are deceased, they have 5 siblings and several nieces and nephews?
To do a will, to sit down and say who they want to get it, because they may like some of their nieces and nephews better. They may like some of their siblings better. They may not want their siblings to get it. If they don't do a will with no parents, no spouse, no children, it would go to their siblings. And they may not want that. And so the will help them decide who gets it.
Okay. How is debt handled if it exceeds the assets?
Debt, and it depends on whether we've got a surviving spouse. In Georgia, there is this, and or minor children. In Georgia, there's a unique petition that you can file called a petition for years support, that if you are a spouse or minor children, you might be able to end run the debt by filing that as a spouse and get away from the creditors and be treated as what we call a first priority creditor and get all the money out of the estate and avoid those creditors. If there is no spouse and minor children, then unfortunately the executor of the estate is going to be responsible for paying those debts off and making sure that those debts get paid. If they don't, that executor could be held personally liable for not paying the debts. And we're about to talk about the process here in Georgia, notifying creditors and other things here on the probate process about kind of what happens after somebody dies. And so that's part of it, is you have to notify or publish to creditors out there and let them know that that happens. But unfortunately, you're likely going to have to pay those creditors first.
Okay. How is capital gains tax applied when a property is left to an heir?
That's a great question. If it's done properly, when it's left to an heir, they get what they call currently under the law a step up in basis on that property. So let's say, and this applies to stocks. This applies to real estate. This applies to anything somebody bought with a cost basis and a new value at date of death. It applies to businesses. Let's say you die owning a house, and the example I used before, mom and dad paid $10,000 for their house, and at date of death, it was worth $100,000. Well, the capital gain would normally be $90,000 that you would pay tax on. But there's a special rule under the law that says at date of death, the value of the house becomes the new cost basis in that house for capital gains purposes. And so that means the kids inherit the house with that new cost basis of fair market value, which is now $100,000. So if the kids turn around and sell it for $100,000, they pay 0 capital gains tax. That's critically important because it's a huge tax. And this is a tax issue for even small estates that people make mistakes on. This isn't your multi-millionaire estates that have this problem. This is your $100,000, $200,000, $300,000 estates. They make this mistake all the time. Mom and dad give their little stock portfolio away to the kids before they die and lock in all the capital gain. They give away their house. They lock in the capital gain. They give away the car. They lock in the capital gain. They give away their business. They lock in the capital gain. These are all bad moves. And so again, you need to see somebody who has some understanding of the tax laws before you do that.
Okay, so another follow-up for capital gains. Do you avoid the capital gains tax if you sell the house to your child for a low fee rather than gifting it to them?
No, because that's considered, what the IRS has got a code for that, and it's called a bargain sale. And it's considered a bargain sale to a related party, and it immediately triggers the capital gains tax. And it's a gift. It's a gift of the differential of the house and the amount. So you do not avoid the capital gains tax because it triggers the bargain sale rules. The IRS was smart enough to see that as a gain.
Okay, one more. What if you have children and you leave the home? What if you have children and you leave the home to children that have spouses and that child dies? Does the spouse inherit their share?
If if the child has, it depends on order of death. And this is again why wills are really important, because the will may address what happens if the child predeceases, but it may not. And if the person who owned the house has already died and left it to the child, and the child is what we call vested in the property. So mom died, left her house to her son, and then son dies 2 months later. Then son's estate is going to determine what happens to mom's house if son had the entire interest in the house. Maybe he had a will that left it to his wife. Maybe he had a will that didn't. Maybe he didn't have a will and it's the wife and his kids. But yes, the order of death will matter there. If the son dies before mom, then it depends on what mom's will says happens. It depends if mom doesn't have a will, then it depends on whether the son has spouse and kids, which in this case he would, which they would be his intestate heirs and potentially receive the son's share. So again, very important to have a will when you have real estate, because it can create major problems. The order of death can change that.
Okay. How much does it cost to get a will drafted?
That's the age-old good question. That's kind of like walking into a car dealership and asking how much for a car. It kind of depends on the options. It depends on, am I getting the loaded bells and whistles? Do I need this really high-end plan because of my assets and what I got going on? Am I doing a lot of trust planning for minor kids? And do I have to name a bunch of beneficiary forms to these trusts and do those type of things? Or is this really just a very simple plan with, name it to the spouse, kids, and I don't have a lot of that other? Those vary. I mean, the simple plans for the will, the power of attorney, and the healthcare directive, at least in our office, run about $750 to $1,000 to do. But once you get past that, the simple basic type stuff, if you start getting into the higher end stuff, I've had estate plans cost as much as $40,000, depending on what we were doing. Now, those were really high end individuals where we were doing lots of LLCs and entities and stuff. But when you get into when you do start doing trust planning for minors and other things, they start getting into the $1,500 to $2,500 range. And you're having to do beneficiary forms and all sorts of trust planning. We're doing rev trust planning where you have to transfer assets and things. You're starting to talk $2,000, $3,000, $4,000, depending on the assets and all of that. So that gives you kind of a range of that level of planning. But the basic stuff is fairly straightforward, and in the scheme of things, not expensive relative to the cost that can happen if you don't do the planning. I mean, $750 to $1,000 may sound like a lot of money until you realize I've got a case right now where there's no will and an estate, and they've paid us $10,000 to handle the estate dispute. And now if they'd had a will, we wouldn't have that. So I think it's relative in the sense that you kind of have to balance $750 to $1,000. Is it worth heading off the $10,000 estate dispute? That's a question everybody has to answer for themselves.
Okay. And one question, we have wills that are 30 plus years old. Of course, things have changed. Do we need to completely do new wills, or can they be amended? I guess like a codicil. Same goes for POAs and healthcare directives.
I would tell you just to do new wills. You could do codicils under Georgia law, but I can tell you why we stopped doing codicils several years back is because we've had situations where people would remove the codicil, throw it away, and try to probate the original will. And so with the advent of computers and word processing, we have found it's much easier to just redo the wills now, particularly for repeat clients. When I have somebody who wants to amend a will we've already done, it's a lot easier to redo their will, to just redo the whole will, than it is to try to do codicils and amend certain sections. And, people have differing feels on that. I just find it's less cumbersome to have to chase a bunch of codicils to a will or attachments to a will than it is to redo the will. And I know I've got the most recent document if I've just got the will. But yes, if your wills are that old, you need to see somebody and POAs are that old, I'd see somebody to have them redone.
And the last question for this section, how can you disinherit an estranged child?
You just simply put that you're disinheriting them in the will. In Georgia law, there's no requirement that you leave them any assets. You just have to acknowledge they exist and say, I don't wish for them to receive anything. And it's that simple. But it's important to do if you plan to do it, and needs to be done in your will if you're going to do it.
Okay.
All
And
right.
I think you can proceed with your
All
popcorn.
right. Well, I'll try to, these next couple sections, I may have to wrap up a little bit quicker because it looks like we're running a little tight on time. And so what I'll do is kind of run through the probate process in Georgia. In Georgia, there are two types of probate process that we typically have. Now, there are a bunch of other forms you file, but these are the two main ones. You have testate and intestate. Testate means that there's a will, and we file what's called a petition to probate a will in solemn form. Intestate is when there is no will, and we file a petition for administration. And I think I've got a little typo in there. There's a double N under administration. So forgive me for my typo. But those are the two processes. The petitions that you file are very similar. In both cases, you notify all the heirs. You know, you send the petitions out, you notify the heirs. In the case of the will, you send a copy of the petition, the will, to the heirs in the estate, and then they send back consents as to whether they agree to probate the estate or not. And the same for the administration, that they agree to the appointment of the person you have selected to be the administrator. Now, when there's not a will, selecting the administrator can be a little bit different because either a majority of the heirs can choose to do it. You know, you can have a fight over who the administrator is, and that can create problems. That's why a will is better, because it helps resolve all of those issues. Wills also avoid all these other unintended inheritance problems of minor children, unwanted heirs, unusual order of deaths, kind of some of the things that people have brought up in the questions we've answered today. So that's what the process is. You will file one of these two petitions with the probate court of the county where the decedent lived. And then once the petition is filed in the appropriate probate court, once the petition is heard by the probate court, that executor administrator will come in to be sworn in, and then they'll get sworn in and be appointed over the estate. And then after being sworn in, a new law just went into effect July 1st that administrator or executor now has to notify all the heirs or all the beneficiaries of testate estate that they've been appointed. And then that occurs. Then you notify the creditors of the estate. You file a publication notice in a local publication in that county. That publication notice will run for 4 weeks, and then there's a 90-day publication period where creditors can show up and file claims within the estate and tell you they exist. And then finally, once you have cleaned that up, you can distribute the estate. Once you've paid creditors, once you've identified all the heirs and been appointed, you go through the process of distributing the estate. And, you know, generally the probate process in Georgia is fairly straightforward. It's not that expensive. And so, you know, it's an easy and cheaper process than most states. So it's not one to be concerned about or worried about. And it's certainly one to follow. Now, as we've talked about before, the benefits to your estate plans in Georgia, the assets go where you want them. No unintended beneficiaries or designations. Avoid the wrong people receiving, maybe a second spouse or other people. Your real estate, which has been a point of several questions today, goes to the right heirs or parties and is very important. And in the order of death may not matter. As the question that we just had just a few minutes ago, what happens if a child dies or a certain order happens? Well, a will can help determine that, can help determine if people pre-decease or aren't there at date of death, who gets the property. So again, that's why probate and wills are important under Georgia and something that everybody should do. Now, I guess that I'll briefly pause here to ask if anybody has any general questions about the probate process in Georgia, Keyshawn, if they do, because I know we're kind of getting compressed here on the back end. And if anybody doesn't have any probate questions or questions about probate and its process, I'll jump into heirs property. All right, I'll jump into heirs property. Heirs property under Georgia law is actually a defined term now under our statutes. And generally, it's considered, it usually means property that's been transferred outside without a will, where I've got multiple tenants in common or a bunch of people owning it. You know, 5 siblings own it, or 2 siblings and 2 deceased siblings' kids. So I've got grandkids and kids owning the property together. We had an estate that we probated recently that there were 37 heirs to a piece of property in that we had to work through and get solved. And it was an acreage of farmland. And it was a mess to clean up. I have another estate in a county that I will not name. There are 253 heirs in the estate because they have not probated 8 of the estates in line in it. And so we have a nightmare of heirs property problem in that one. And so that's, people ask about probate and why it's important. That's the other point of probate. Probate helps clean up heirs property. It helps keep it from occurring. And people make this mistake when mom or dad die. They just don't probate their estate and get the deeds and the real estate records cleaned up. And then we end up being 15, 20, 30, 40 years down the road trying to clean these deeds and this real estate title up. And we end up with heirs property. And as I talked about before, the heirs property statute in Georgia is a little bit unique in the sense that it creates a mechanism for 20% of the heirs to get together and force the sale of the property or get the property partitioned and divided out. And that can create huge fights and problems, but it can also get all of the parties out of business with one another. And so if that's occurring, that's what the heirs property in Georgia was designed to do, so that you didn't have these other problems that are occurred that I've pointed to here, that it's hard to sell the property, hard to get loans or mortgages or crops dealt with, or timber harvested, or deal with ag programs, the agricultural programs of the USDA or your local ASCS office or FSA office, and getting them signed up. You have to get everybody signed. I mean, those type of problems occur with the heirs property that create major, major issues. And so I would tell you, if you have that problem, please consult somebody who's qualified in the real estate and those type of issues so that they can be addressed and dealt with under heirs property in Georgia law. And then again, I reiterate what happens without a will. This is what we talked about before. You have the intestacy laws under Georgia, and this is that heirs property type of stuff. And you just don't want that. You end up with all sorts of family members and people owning it, and it creates a real mess for trying to sort it out and clean it out. And I would encourage you to do wills and probate estates so that these type of things don't happen. And then finally, as I said, the ways to prevent heirs property, wills, and wills. That is a great way to do it. We talked about the LLCs briefly. Maybe you have rev trusts. Joint ownership, again, has taxed the capital gain problems we talked about and creditor pitfalls we talked about, but it's another way. And then some people do life estates where somebody talked about what if one child's on the deed is the remainder type thing. Well, again, that has possible tax pitfalls for capital gains, as well as we disinherited a bunch of kids. So the best way to prevent that heirs property is LLCs and wills. Those two, think those two if you're thinking about it, and talk to somebody who's qualified and putting them together and knows what they're doing to get them right. Because you just don't want to do it. If you have an heirs property problem, talk to a good probate lawyer or estate lawyer who knows how to clean them up, or a good real estate lawyer who knows how to clean them up, because they are going to take some time and it's going to cost some money. And that's the bigger problem. It's the monetary cost that these things take to clean up. And all they had to do to avoid them was a will. That $750 will versus the $10,000 heirs property cleanup, I can tell you, is much cheaper. And so I would encourage everybody to do it. And don't wait till this point in time, as most of my clients seem to do over the years. You know, spring is coming and poor Frosty walks into my office in March and he's beginning to melt and needs an estate plan, or grandma's in the hospital and we need a will. Try not to get caught in those situations. Try to do them ahead of time when you can sit down with the planner, go through them and do them. Because again, tongue in cheek, you don't want to be part of this service where it's death and taxes at the same time. So, that concludes my presentation for today. I'm happy to answer some more questions and go through anything, or go through probate or heirs property in more detail if people have any additional questions.
Okay, thank you so much, John. We are a little over time, but John has agreed to answer more questions. We do appreciate that. If you have to leave, we do have in the chat box, if your chat is enabled, we do have a survey, a questionnaire, like we have always collect information, an evaluation, if you will. So if you would please answer the evaluation. We want to host more of these later on. We want to see how we did today. We want to improve as well. So please answer the, click the link in the chat box. For those of you that registered via, and we have your email, we will send the evaluation link afterwards. And there have been several questions about the slides. The slides are John's property. However, we will have a recording. It will be housed on the FVSUag Facebook page and later on the YouTube page. We will send an email telling you where you can find the recording in case you missed something. Also, before you leave, if you leave, of course, you're welcome to stay on and answer and listen to the answers for these last few questions that we have for John. But I would like to introduce our committee to you guys. These are the people responsible for making these things happen. I'm going to ask the committee if you're able, if you would turn your cameras on right quickly for us. And we're going to start off with my wonderful co-host, Brenda Salter. She is a Family Consumer Sciences agent for Fort Valley State Cooperative Extension. We have Ida Jackson. She's the Family Consumer Sciences agent for University of Georgia Cooperative Extension. We have Joshua Dawson. Give me a wave, Joshua. He is an Ag and Natural Resources agent for Fort Valley State University Cooperative Extension. We have Millicent Price. Hey, Millicent. She's a Family and Consumer Sciences agent for Fort Valley State University Cooperative Extension. We have Philip Petway. He's a 4-H agent for Fort Valley State University Cooperative Extension. And Titus Andrews Sr. He is an Ag and Natural Resources agent for Fort Valley State University Cooperative Extension. And we also have Mark Thomas, who is an administrator at Fort Valley State University Cooperative Extension Program. And of course, yours truly, Keyshawn Thomas, UGA Flex Agent for Valley, UGA Extension. I got confused. I don't know who I work for. Now, we do have a few more questions, and they are very good questions. So, John, I'm just going to kind of go through and send them to you or give them to you as we've done in so far this morning. So the next question is, if you have a copy of a trust, where can you get another original copy if the lawyer has died and his office is closed?
Yeah, oftentimes you can call the state bar and see if that lawyer left a forwarding lawyer or somebody to handle his files or who was in charge of his files. It's going to be difficult if that hasn't occurred. If you have a copy of a trust, sometimes you can use that and have it used in cases. If the trustee still exists and there's a trustee over that trust, you can get them to do what we call a certification of trust, that they can do an original document to certify the trust still exists, and do that under our law. But if you're looking for the original document and you need the original document, that might be a sticky situation if that lawyer didn't leave a forwarding, because we as lawyers are supposed to maintain our files and keep them forever, which is also, people don't realize that I'm obligated to keep all this paperwork until I close my office. And then when I do, I have to write all my thousands of clients that I've had say, come get your paperwork. And that doesn't always work real well, as you might imagine. So, but yeah, those are the avenues to try to figure that out.
Okay. If there are more than one heir to a property that needs to be sold, does it take all owners to agree or a simple majority?
It depends on how you're going. If you're selling it through a normal private sale process with a closing attorney, yes, all the heirs would have to sign off on it. If you are trying to sell it through a forced sale of either a court partition or an heirs property sale, then it would only take 20% of the heirs to be able to force the sale through the court process. But there again, there are pitfalls to the court process, because you could end up with a smaller value, a fire sale value, those type of things. And that's why, again, it's good to try to clean up the heirs property before you get to that point.
Okay. If property and land was deeded to heirs, can the heirs LLC the property and land, and would it be smart to do so?
Yes and yes. Yes, they can. As long as all the heirs sign off on it, they can transfer a deed, transferring title into that LLC. I would tell them they need to set up an operating agreement with that LLC that determines how the LLC operates and functions. But yes, and that would be a very smart thing for them to do.
Okay. Do you have an unlimited time to probate a will? I think you answered that one.
Generally in Georgia, yes.
What about TOD for property? Is it good?
Typically, no, because it creates, that's more of what we call a life estate situation. It's really more of a life estate is what you're referring to. TOD is more bank accounts and stock accounts and even securities or LLC interest or those type of things or shares in companies. Whereas a life estate is where you maintain a life interest in the property with remainder to kids or other people. And so when you're doing that, that's really a life estate deed that you filed in with the property records. I would tell you don't do it or seek somebody to walk you through it if you're going to do it. But there are rare occasions to do a life estate deed. But for the most part, we don't do them.
Okay. To become a power of attorney, do all immediate relatives need to be informed?
No. Under Georgia law, there's no requirement that you notify people of a POA. You don't have to even notify your POA that you've nominated them. They don't have to sign anything. The POA is either effective immediately upon signing or on disability, depending on how you structure it. Now, I would tell you it's good form and policy to notify your agent that you have appointed or send them a copy of it and tell them how it's effective and the rest. But there's no requirement that anybody knows you have it or that it's done.
Okay. Does a co-trustee on a bank account have the same liability as a joint owner?
A co-trustee on a bank account can have certain liabilities if the other trustee goes and steals money. Yes, there are cases out there where if you let a co-trustee do it, you don't object and you don't tell them, hey, I'm not a party to this, or you don't notify the beneficiaries that that's going on and bad things are happening, you could have some fiduciary responsibility if somebody's stealing from the bank account. Yes.
Okay. If I just saw this question, oh my goodness. Okay, what is the average cost of probating heirs' property?
That depends. It depends on how many heirs there are. It depends on how involved the property is, how fractionalized it is. If I've got a few heirs, it's like a normal probate. $1,500, $2,000. If I've got 25 heirs that I'm chasing, we had one that took $7,000 to $10,000 to get cleaned up because of that. Because it just took that much time to notify them, to serve them, to find them, to get them to sign up. It's a difficult process to get that type stuff cleaned up.
Okay. If an estate is settled and then years later an heir shows up claiming to be a child or adult child of the deceased, can he or she receive proceeds or property from the estate?
They can seek to do it. It depends on how they were notified. Was the estate, were they ever put on notice? If they weren't put on notice, it could create some problems within the probate of the estate. And you'd have to look to statute of limitations and other things, whether they were told, whether, they still had a right to claim it. There are a myriad of issues. It depends on when they come forward. It depends on what the estate value was. All those type of things can play into it. So I'm going to give you the typical lawyer answer. It depends. That one is factually driven. And so it's going to depend on the circumstances.
We have a question. When did the spouse's share become a third in the state of Georgia?
That's a great question. 1938, maybe? It used to be dower. It was 25%, maybe in the 20s and 30s, and maybe it was the 50s, 60s. I don't remember. It's been a long time. But the intestacy rules have been around for a while. So it's been a third it's a half if there's only one child. It's a third if there's more than one child.
Okay. Can you do your own will?
You can. Just like I could do my own appendectomy, but I'm pretty sure it's going to hurt and I'm going to have trouble doing it. And that's why I'd seek a doctor. As I had a client come in one time who was a doctor and had drafted his own will, I told him, I said, I have two things to tell you. I have good news and bad news. He said, well, what's the good news? I said, well, the good news is the will you have drafted is valid and enforceable under Georgia law. He said, what's the bad news? I said, the bad news is the will you've drafted is good and enforceable under Georgia law. And because he had a situation where the way he drafted it, he disinherited one of his kids. Didn't know it. Didn't know the language in the will did that. Didn't understand that that's what it did. If a certain order of death happened, one of his kids got kicked out. And he had no idea that's what happened. And that was not his intent. So sure, you are allowed to draft your own will under Georgia law as long as you follow the formalities of 2 witnesses and execute it properly and do those things. But it may have some unintended consequences of how it devises your estate.
Okay. Now we have a follow-up question. What's to stop one sibling from filing the paperwork superseding the other sibling as power of attorney?
Well, that does often happen where we have the race to the lawyer's office to take mama to go sign a power of attorney, and one lawyer drafts one and one lawyer drafts another. Then we start getting into competency issues, because if that's happening, is mama competent? Does she know what she's doing? Does she understand what she's doing? And if the answer to any of those is no, then we are probably now instituting a guardianship and conservatorship proceeding in the probate court where we're going to fight over who's going to be mama's conservator and guardian. And it'll be important who was named as POA, but it won't be the end all be all. And so ultimately, we will be trying to supersede those documents because we're not sure mom's understands what she's doing. Now, if mom understands what she's doing and she took one child out because she didn't like what that child was saying she was going to do or he was going to do, and mom is perfectly capable of doing that, then you're SOL. You are out of luck because mama could make that change and you are on the curb as the POA. So it depends on the situation and whether the person doing it is competent or not. But that's the general fact pattern we see happen in those cases.
Can an executor get around creditors in probate?
Yeah, I mean, you can. And what we usually do, oftentimes it's credit cards and others. We find that we can negotiate with them. Sometimes they'll negotiate down. They'll negotiate payoffs. They'll negotiate settlements. So that is one way to do it, but you can't just ignore them. You can't just say, they were creditors, I'm just going to distribute the estate and forget they existed. That's the duty of the executor, is to marshal the estate assets, collect it first for the creditors under Georgia law and second for the beneficiaries. And most people don't realize that. That's the executor's responsibility. And they have a duty to the creditors as much as they do the beneficiaries. So their job is to make sure that that estate is clean, because what you're trying to do is ensure that title to the assets is clean and transferred clearly to the beneficiaries, so that there are no more liens on the vehicles or the mortgage is not that, those type of things are done. And so that's the point of the probate process too, as well as to clear out debts of the decedent.
Okay. With heirs property, what's the process of getting it probated to have more structure, and who would be entitled to have authorization to do so if there's a large number of heirs, like 100+ heirs?
Okay. If there are 100+ heirs, somebody's going to have to seek to be appointed administrator of the estate. And they're going to file to be appointed administrator of that estate. And the heirs, a majority of the heirs can select that. If a majority don't agree, then the probate judge is going to pick who that's going to be based on a hearing. And so you'll all trundle into the courthouse and fight out who's going to be the administrator. Once you have an administrator, that administrator can start untangling the division of the deeds and how to divide the property out. They might do deeds of assent and just start distributing the property out of the estate in fractional shares to everybody. That creates a mess, but it gets it out of the estate. And then suddenly the heirs are all fighting over it as their own property that they own. And then it's a different fight where they have to pay for their own costs outside of probate to go create a court action on their own as the individual owners.
Okay. Is a life estate a living trust? If not, what are the pros and cons of living trust?
No, a life estate is not a living trust. A living trust is what I was talking about before, which is called a revocable trust. Revocable trust and living trust are synonymous under our law. They're the same name for something. And so a living trust is a trust that you set up during your lifetime and you put all of your assets in it. It's like a big walking pocketbook. You carry it around. You can amend it or change it at any time. And that's what revocable or living trust is. A life estate deed is a deed done in the deed records that transfers the property immediately upon filing to a remainder.
If the assets are exhausted before all debt is paid, is the executor liable to pay back the remaining debt?
No. The executor has to prorate the estate among the creditors. Then there's a priority of creditor order payment under Georgia law that you have to pay, and there are levels of creditors. And so you would just prorate the estate among those different, working through the levels of creditors and paying them off. But once you run out of money, you are not responsible for paying above that. You just tell the creditors, sorry, we're out of money.
Okay. If the person is already dead, can the executor try to disinherit an estranged child?
No.
Okay. And if a spouse was given bad information by an attorney that she would get a child's part, is 3 children, and when she made her will, she stated my part, and she put a 4th part, would her part be a 4th or legally a 3rd?
I'm not sure I'm understanding that question.
It sounds like they made, she got advice from an attorney and they said that her part would be a 4th part. And so she put that in her will, that her 4th part or whatever this property asset is.
I see, instead of a 3rd.
Yeah, she's trying to see if it's a 4th or a 3rd.
It's well, depending on, well, if she inherited it through a will, it might be a 4th. If he set out a will and did that, then it would be a 4th, because you can change the intestacy rules by doing a will. Mm-hmm. So if she inherited that through a will, then it wouldn't be bad advice because the lawyer set it out she was only going to get a 4th, but through a will. But if it was through an intestacy or no will that she inherited, then she would get a 3rd. And then she would be leaving a 3rd instead. But if it was a 4th in a will, then that would have been correct. That wasn't bad advice. That was what the will said.
Oh, she said she did not inherit through a will.
Okay. Then it should have been a 3rd rather than a 4th.
Okay. And that somebody wants to know if there are CLE credits for this seminar for attorneys.
Probably not. I have not gotten approved by ICLE to get CLE credits for this. No.
Sorry, Mr. Bryan. So if there are absolutely no assets available when the person dies, who pays burial costs? Except surely they just leave the body in the morgue.
Well, the funeral home is going to want to get paid. Usually they'll seek payment on that before they take on the services, or find a way to get paid before they take on those services, has been my experience as a practical matter. So, you know, ultimately times what people end up doing is they end up getting to a cremation point with that because it is a cheaper alternative.
Okay. And last question, what's the process of leaving a home to your children?
Well, it's just putting it in a will. I mean, setting it forth in the will if you want to leave it to them, or leaving the residue of your estate to your kids, which will pick up your will. Pick it up in the will.
Oh, and people want your contact information.
Okay.
And also, are there any avenues for low cost for people that don't have a lot of money to get wills created?
Yeah, there are. The Georgia Legal Services Program in Georgia, they have offices throughout the state. I know there's one here in Augusta. Oftentimes they will have wills clinic days or will drafting days, or they will set appointments for indigent people or people who need some assistance to do that. I know I've been a part of wills clinics in the past where lawyers and pro bono people will draft wills clinics or wills for folks. But those are the places to go for those type of things. Georgia Legal Services is the best starting point.
Okay. And also there's a great program, Georgia Fits. We also help people to draft wills. John is one of the attorneys that work with us, and it's absolutely free, but we do ask that you contact one of the agents that are involved on the committee, and we will be putting out a call at some point to do more wills. On the slideshow earlier, we have completed 59 in the past about a year and a half, 59, and that has translated into over 100 some odd acres being transitioned into an estate plan. So we're pretty proud of that. There is one last question. What certifications or credentials Do you have to be a planner? You mentioned one earlier.
Yeah, I would say most people, experience helps for sure. You can gain it through experience and working with a firm or working with someone like me under my tutelage who does it. But usually I'd look for somebody who has an LLM, who holds themselves out as an estate planner and asks all those right questions that says, hey, what are your assets? What's going on? Where are we with this? And those type of things. Because if they're not asking you the questions of what do you have, who are your kids, who are your possible heirs, how in the world can they even draft a will for you? How can they even possibly get your estate plan right if they don't know the right questions to ask? So that's going to be a pretty clear indicator up front if they've got the requisite experience, if they are asking the questions. If they are just saying, who do you want to give it to and where does it go? And they're printing out a form for you, that's probably not the planner you want, because they're not a planner, and they probably don't. And ask them questions. Ask them, do you understand the tax implications of IRAs and 401ks? Ask them, do you know how to transfer the real estate under the will if something, ask them some general questions before you retain them.
Okay. And I think that is it, except for, does Middle Georgia Justice probate heirs property?
Does Middle Georgia Justice?
Probate. And that is a local organization in Middle Georgia. And I'm not sure, they may probate heirs property, but we do have the Georgia Heirs Property Law Center. They specifically work with heirs property. And John mentioned a few things about not creating heirs property as we are creating our estate plans. So we also want to keep that in mind also. I think he said Georgia Legal Services,
yes,
about helping people to draft the will, and also Georgia Fits. All of us are involved in this Georgia Fits project, and we will be having opportunities for people to get 3 documents drafted free of charge. They'll be upcoming. And we'll reach out to everybody that has registered through this webinar. Though you guys will be our first people that we will send calls out to. And also it's contingent upon funding. So keep that in mind. I would like for everybody to remember to fill out our survey. Our evaluation is in the chat if your chat is enabled. If not, we will be sending an email with the evaluation link. We want to hear back from you. We see some great things going on in the chat, saying that this is a great workshop and looking forward to future opportunities. But we would love for you to fill out the evaluation as well so that we can improve and continue to offer these free of charge. And I think this concludes for today. Also, we would like for you, it does no good if you get the information yourself and you don't share it with your loved ones. Share it with your loved ones. This is a topic that I think crosses socioeconomic, gender, race, all of those things. We all have to plan for the inevitable. It's going to happen. Death and taxes, as John's last slide said, death and taxes are absolutely sure. So we have to make sure that we plan for it. Share it with your friends and loved ones. It may not be the easiest conversation at the dinner table. However, it is warranted. And we have learned today that by not having an estate plan, we can cause ourselves or our loved ones to have to pay a lot more money than if we go ahead and we just do an estate plan. Brenda, do you have any final words for everyone?
No, I don't. I think you covered everything. Thank you. Just thanks to everybody for joining us.
It's been a pleasure. Thank you so much for joining us. Remember to reach out to your county extension office. We're a wealth of knowledge. We have lots of different things going on, and we appreciate everyone for joining us today.
Thank you for giving me the opportunity to be here today as well.
John, if you would hang on for a few moments. Ida, if you would end for us.